Order, order. Lawrence Turner to move the motion.
Thank you, Dr Mewison, and it's a pleasure to serve for the first time under your chairship. At the outset, I would like to thank the members of the Backbench Business Committee for agreeing to allocate this debate and all the honourable members across parties who supported the application. I would also like to thank those constituents and members of the public who have been in touch in advance of this debate. Criminal injuries are, by their nature, not easy matters to discuss. So I am grateful to all those people who took the time to recount their experiences, and indeed I'm grateful to all the members who are here today. I would like to mention in particular my honourable friend, the member for Warrington North, who has already done much in this Parliament and in the last to highlight some of the problems that we will talk about today. It is also good to see the honourable member for Strangford in his place. I should make it clear that when I talk about the Criminal Injuries Compensation Scheme, I refer to the scheme as it operates in Great Britain. But I am aware that different arrangements apply in Northern Ireland, and I'm glad that that perspective will be represented today. It is important also at this early stage to pay tribute to the staff of the Criminal Injuries Compensation Authority. Nothing in the opening of this debate is intended as a criticism of them. They work under parameters that are broadly set by us in Parliament, with staffing numbers that have fallen 19% since the current iteration of the scheme was introduced in 2012. The Civil Service People Survey reveals that they take pride and purpose in their jobs, and I am grateful to them. Dr Mewison, the question of how the victims of serious physical and mental criminal injury may be fairly compensated has occupied this House for many decades. We are to the month at the 60th anniversary of the introduction for the first full year of the original non-statutory scheme, which was introduced in recognition of the fact that there will always be cases where the perpetrators of serious violence cannot be identified or when awards cannot be recovered from their assets or incomes. In preparation for this debate, I was delighted to learn of a local connection that the guiding and determined force behind that original scheme was the Birmingham magistrate and the first secretary of the Howard League for Penal Reform, Marjorie Fry. She was a tireless campaigner up to her death for better support for the victims of crime and the principle that perpetrators must, wherever possible, pay the cost of restitution. These are principles that I'm sure members on all sides of this House will endorse today. But there is another, an unhappy point of emerging agreement around the Criminal Injuries Compensation Scheme. It does not adequately serve the people it is meant to aid. As the Victims Commissioner put it in 2019, victims of violent crime report delays, uncertainty about next steps and poor communication. She went on, to many, fairly or unfairly, the scheme seemed calculated to frustrate and alienate. I will give way.
Thank you for giving way and for tabling what is an incredibly important debate. I've come upon this issue recently because I've been dealing with the case of a 10-year-old boy in my constituency who was shot in a quiet residential street. It has taken 5 years to get him compensated for the injuries that he has suffered, which are now lifelong. Does he share my concern about the sheer length of time it takes to get victims compensated, the bureaucratic and sometimes impersonal approach, and the inadequacy of the sums being received by people, particularly children, who have received lifelong injury?
Well, I thank the Honourable Member for her intervention, and she raises what sounds like a truly shocking case, and all my sympathies are with that child and their families. I agree wholeheartedly with the point she makes about timelines and the nature of communication through the scheme, which I'll come on to, and I'm sure other members will come on to in the course of this debate. And at the time, the Victims Commissioner further recommended that the Ministry of Justice examine the scheme with a view to making it simpler and accessible to victims wishing to apply on their own behalf, reducing the reliance upon legal representatives. Also in the last Parliament, the All-Party Parliamentary Group on Adult Survivors of Childhood Sexual Abuse reported that almost all survivors that contributed to their inquiry had a negative experience of applying to SEEKR for compensation. Now, I do recognise that some progress has been made in the last 6 years, which must be welcomed. The last government did, retrospectively, remove the under the same roof rule for crimes committed between 1964 and 1979. It had been long recognised that this rule prevented fair compensation from being awarded to the victims of historic domestic abuse and childhood sexual abuse during that period. And progress has been made more recently to reduce the paper-bound nature of the scheme. But standing here today, we cannot reassure ourselves that this scheme is in good health. As has already been said, the victims of violent crime can face long delays before they access compensation. For residents in Birmingham, the average time between application and award is still more than a year. Now, that average can be dragged upwards by the most complex cases, but even apparently simple cases can take many months to resolve. Applicants to the scheme are not effectively signposted to wider support or assisted to navigate the processes for accessing those services, such as NHS post-traumatic stress disorder diagnosis. The reasoning that underpins the tariff system is hard to understand, and the apparently arbitrary limits to the scheme can produce outcomes that are, to the layperson's eye, perverse. The 2-year normal claim limit is also out of line with the 3-year limit for civil claims for injury.
Please give way on that point.
I will give way to my humble friend.
Thank my honourable friend for giving way. Does my friend agree that it is totally inconsistent when we have a time limit of 3 years for ordinary personal injury claims, but a time limit of only 2 years for criminal injuries compensation authority claims? There is a reason why there are time limits, memories fade and evidence becomes less reliable. But does he agree that there should be consistency here?
Well, my humble friend is very learned and experienced in these matters, and I wholeheartedly agree with the point that he makes. I think this discrepancy is hard to explain, especially as the pre-1996 non-statutory scheme explicitly aligned the civil injuries, criminal injuries, time limit with that for civil claims. There is some evidence also that those victims who have legal representation often receive greater compensation than they would have if they acted alone. This is not a desirable outcome, especially when people with more limited means are more likely to become the victims of crime. The scheme's tariff has not been updated since 2012, but its upper and lower bounds have been frozen, despite inflation, for many years before that. Indeed, the lowest tariff of £1,000 has remained frozen since 1992, a real terms erosion of 54%. The process can feel cold and impersonal. As one member of the public with recent experience of the scheme who wrote to me in advance of this debate put it, the lack of timelines or updates means victims are continually left in limbo and re-traumatised by a process that is meant to help. I will give way.
I'm very grateful, both for the fact that he's got this debate and also the way he's setting out the problems with the scheme, which is something of a Cinderella service. As he said, tariffs haven't changed. The upper limit hasn't changed for almost 30 years. But I think what gives away the situation even more is the fact that whereas the average sum awarded in the last year, which we know about, was just about £8,000 per case, when that was appealed, it increased sixfold. So clearly that, and also the fact that only 3% of injured victims of crime are actually receiving compensation, suggests that there are things wrong here with the scheme.
I think my humble friend, the chair of the Justice Committee, makes a very important point, and we must consider also the number of victims of crime who are so exhausted by the process that they may have grounds for an appeal, but they choose not to do so. And his scrutiny in this area is very welcome. Now, changes made to the scheme have an unhappy history in this House. Some members may recall the very contentious changes that were made to the scheme in 2012 with the express intent of reducing expenditure by between 40 million and 60 million a year. At the time, in the face of sustained scrutiny, including from members of the then government benches, the Minister of the day, the Honourable Member for Maidstone and Malling, announced in her words, a hardship fund of £500,000 per year, which will provide relief from hardship for very low-paid workers in England and Wales who are temporarily unable to work as a result of being a victim of a crime of violence. That concession secured support for the relevant secondary legislation. The fund is still in existence, but its criteria are so tightly drawn. An applicant must be paid no more than £5,700 a year, the equivalent of statutory sick pay, and they must apply to seeker not within 2 years of an injury, but within 2 months to qualify. Far from supporting low-paid victims of crime by £500,000 a year, the Ministry of Justice told me recently that just £4,100 has ever been paid out of that fund, and no payments at all were made in the 7 years to 2023-24. I suspect that the very few eligible workers were even aware that it exists. The hardship fund is a dead letter, and it would be better to scrap it than claim that special support is available to low-paid workers when, in practice, it is not. I'm delighted to give way.
I thank my honourable friend for giving way, and when he references low-paid workers, we know that retail staff are among the victims who experience a really shocking amount of violent crime within the workplace. Does he join me in paying tribute to the work of the trade union USDOR in the work that they're doing to make sure that their members who are victims of violent crime in the workplace can access the seeker scheme?
Well, I thank my honourable friend for her point, and I do agree. USDOR's Freedom from Fear campaign, which has been running for many years and covers a number of important points, including the importance of fair access to compensation, is to be welcomed, and they should be congratulated on the changes that they have secured already in this House. Another high-profile change was the tightening of the criteria so that it only applied to injuries caused by deliberate violence inflicted by a person. Now, this change excluded most dangerous dog attacks, and in practice, compensation can only be secured if it can be shown that a dog was directed to attack by its owner. It seems a serious flaw, Dr. Murison, that a child or postal worker may be mauled by a dog and left with life-changing injuries, but the keeping of that dog may itself be an offence under the Dangerous Dogs Act, but there would be no route for compensation, especially if the owner could not be identified. Now, the Communication Workers Union continues to campaign on this issue, and ahead of this debate, they have drawn attention to figures that show that 200 Royal Mail workers each year lose a finger or part of a finger to a dog attack. So I do encourage ministers to look again at this issue, especially in light of the growing number of animals belonging to new and now banned breeds such as the XL Bully since 2012. Indeed, as has already been said, compensation for criminal injuries is an important issue for workers in public-facing roles more generally, and I am grateful to USDOR, GMB and Unison alongside CWU for their work to draw attention to the risk of violent assault to their members, and for the avoidance of doubt, I draw attention to the support provided to my constituency party by GMB and Unison. Now, shortly before, these changes to the scheme were made under the previous government, but I wish to press the Minister on 2 further and more recent points. First, shortly before Easter, the Department published its response to the consultations undertook between 2020 and 2023. In that response, the Ministry said that there would be no immediate changes to the scheme, citing, in part, resource constraints. The decision not to accept recommendation 18 of the Independent Inquiry into Child Sexual Abuse has understandably caused disappointment and reignited wider criticism of the scheme. Now, the government cited 2 factors: protection of universality, that is, treating all applicants the same, and cost. Now, if the scheme will not be amended to provide different criteria for the victims of childhood sexual abuse, what other steps will the Ministry now take, such as the provision of enhanced guidelines on the circumstances under which an out-of-time application would be accepted, taking into account our modern understanding of the lifelong effects of that horrendous crime? And on resourcing, will the Minister accept that while by the nature of the scheme expenditure does vary year on year, the cost of compensation has actually fallen on average, on trend, after inflation is taken into account? And although the number of applications has risen, that rise appears to be driven by an increased number of ineligible claimants. The scheme overall costs less than it did before 2012. Indeed, I believe we spend less in cash terms than we did under the pre-statutory scheme. And as mentioned, Seeker's headcount has fallen. So reforms are needed, but I am concerned that we seem to be talking again about protecting the sustainability of the scheme. I know that the Minister has a very strong personal commitment on this issue and to enhancing support for the victims of crime more generally. And I hope that she will be able to reassure us today that any future reforms of Seeker will seek to improve victim support, including in its compensation elements. Now, Dr. Mewison, when our constituents elect us, they expect us to bring our knowledge, judgment, and also the benefit of our experiences to this place. And like some other members of this House, my interest in this matter arises partly through my own direct experiences of the scheme. By their nature, such matters are difficult to talk about, and if I stumble, I must ask for members' patience. Some 6 years ago, I was on the wrong end of an attempted robbery. I was left concussed, my arm was dislocated, one of the joints in my right hand was shattered. I was physically unable to leave the house for a month, and I had frozen shoulder for a year. There are long-term physical effects. I have premature arthritis, and there is permanent loss of movement on my right-hand side. By any common-sense judgment, these are serious and blameless injuries arising from violence. But with one minor exception, Annex E of the scheme does not recognise them as such. There was, and is, a psychological effect too. An event of that kind changes a person. And I am changed in ways that I still find difficult to talk about. Something I have learned is that recovery is not some happy state that is one day achieved. It is a process that follows its own timetable at an uneven pace towards a destination that can never be fully reached. Now, in that case, the perpetrators were never identified. I incurred substantial costs because the assault happened almost on my doorstep, and while I would be unlikely to recognise the perpetrators, they would have recognised me. At the conclusion of that investigation, the police referred me on to the Criminal Injuries Compensation Scheme. Now, my experience of the scheme was typical of the delays and impersonal contact that's already been described and do not require repeating. What I will say is that when a person is compelled to relieve those experiences within a system that they feel they have to fight against, then that original injustice is continually visited anew. At the conclusion of that process, I received the lowest tariff award of £1,000. That award was given because there was some post-surgical scarring, the only injury that qualified under the scheme. In truth, that aspect was the least consequential effects of the assault. The criteria felt, and they feel today, to be arbitrary. I received an apologetic letter from one of the administrators of the scheme, and I remain grateful for that human touch. The award did not, as it does not for many, cover the costs, travel, accommodation for surgery, physiotherapy, but after 3 years from the assault, I was just glad to have some official recognition, and I did not pursue an appeal. I do not say any of this to attract attention or sympathy, or to suggest that my experience was in any way exceptional. The point is that it was not. And like many victims of crime, my hope now is that some good may come from adverse experience. In that respect, I agree with the Minister when she said recently that the clear message to me is that we need change, and I will be considering how governments can best provide the support that victims need and deserve, and I hope that we will hear more about those plans today. I'm also encouraged by the Prime Minister's clear and personal statement of support for the victims of crime in response to my humble friend, the member for Warrington North, last week. Next Tuesday, I am glad to have the opportunity to bring a 10-minute rule motion to the House that aims to secure the wholesale review of Seeker and the scheme that the Victims Commissioner called for in 2019. The victims of violent crime deserve better, And I hope that that bill will secure cross-party support.
The question is that this House has considered the matter of compensation for criminal injuries. I call Jim Shannon.
Mr Chairman, first of all, can I thank you, and pleasure to serve under your chairship, and can I thank the honourable member for Birmingham Northfield for setting the scene. Nothing tells a story better than a personal one, and the honourable member has done that and done that very well, and I understand that. And it's never easy telling your story, but well done to you. Okay. This is an important debate, as the honourable member has rightly said at the very beginning, the system is very different from Scotland, England and Wales as it is in Northern Ireland, but the principle of what the scheme tries to achieve is the same. So I thank him for bringing this to Westminster Hall for debate. Also a pleasure to see the Minister in place. Look forward very much to what the Honourable Lady will reply on all the questions that we're going to ask her, which are relevant to this debate. There is no excuse in today's society for crime, especially violent crime, which can devastate lives both mentally and physically. Because there's always you can't always see the impact of the crimes on somebody when you look at them, but because some people they hold their emotions in check and internally. You can often feel like every day you hear horrific stories of people who have fallen victim to violent crime. And as the honourable member stated, many will be aware of slightly different legislation between Northern Ireland and the rest of the United Kingdom. But it is great to perhaps add an Northern Ireland perspective to this debate, and I wish to do so if I can. The scheme provides, Mr Chairman, compensation to victims in addition to families of loved ones who have since passed away due from impacts of the violent crime. The scheme that the member talks about is very clearly England, Scotland and Wales. And Northern Ireland, we have a slightly different credentials in relation to it. As of the latest figures available, Mr Chairman, roughly 12,000 to 15,000 applications for criminal injuries compensation are received annually in Northern Ireland. So there is quite a large number of them that go through the process every year. Historically, around 60% of those claims have been successful, while 40% were declined due to not meeting the eligibility criteria that is put forward. But it is important, Mr Chairman, to note, and I believe it is, that often victims are unaware of the grounds on which they can apply on. So this debate today, I think, and I believe the purpose that I would wish to achieve by my contribution will be to raise awareness, ensure that those who maybe don't know their rights, don't know what they can do, will be able to do so as a result of this. And one of the big issues being that the perpetrator does not actually have to be charged with anything for someone to claim compensation. Important to note that if you feel threatened, if you feel you've been abused visually or maybe not physically, then there is a compensation system in place. And that applications can still be made 2 years after the incident occurred, providing it wasn't reasonable for an application to be made at that time. So there are things in the system which I believe are important to record and to have in that place. Very happy to, yeah.
Thank the honourable member for giving way. Just on the issue of entitlement, would you agree with me that it is important that those who do feel very badly affected by some abuse or attack that they've occurred, that they know and understand the system, but at the same time that the system has to bear down on the very small number of people who abuse the system in deference to those who are quite entitled and should seek compensation because of the attacks they've suffered?
Yeah. The honourable is right to highlight the point that there are some who abuse the system. I have to say, in my experience, Mr Chairman, I haven't come across any of those, to be fair, and therefore I can't make an assumption or a statement in relation to it. But I do know that the very nature of any system that you have, there will always be those who will try to take advantage of it. Furthermore, there have been ongoing concerns and issues surrounding the compensation scheme as it is. Many state that there is a complete lack of awareness surrounding the scheme in general, and people are unaware something like this kind even exists. So I suppose my major question to the Minister will be what will be done to highlight the system in place, those who can qualify, and to encourage those who should be doing so to do just that. This has to be addressed, raising awareness, know your rights, as was the way I would put it. For people who have gone through harm, they are deserving of something, Mr Chairman. For those who have lost a loved one as a result of violent crime, there is no amount of money that will take that pain away, but it is deserving based on the trauma that they have experienced. Many who are victims may wish for it all just to go away, And I suspect that might be the case for some, rather than pursue a claim even if they would qualify. One of the big ones, Mr Chairman, is that there's no doubt that this is a traumatising process for so many, and having to relive this through an application can be re-traumatising, living through the horror twice of the memories and the trauma and all the pain that they have when they think of it. I wish to mention a particular case and a section of people, especially in relation to sexual or possible domestic violence crimes, and for others reliving the passing of a loved one. To mention briefly, it was ruled in 2023, Mr Chairman, that victims of non-touching sexual abuse are eligible for compensation under the CICS. There are so many people that have fallen victim to this, especially young people who have gone on to feel the effects of this for years and years. And it's really inconceivable to understand how young people deal with what has happened to them in the past. So I look to the Minister for clarity. The Minister has been always very positive in her answers to all of us in relation to this. And I know it's a subject matter that she is very much on top of, and I look forward to her response. So I look to the Minister for clarity, as this applies to CICS for England, Scotland and Wales. And if the Minister will very kindly, as she always does to be fair, to see if our legislation in Northern Ireland through the Department of Justice can be strengthened along the same guidelines as it is here on the mainland. And to conclude, Mr Chairman, it is a sad reality that so many who are victims of crime, that leaves a devastating impact both physically and mentally. For people of all ages, the effects can be the same, and often, very often, no amount of money can bring a loved one back or remove the mental torment of the past. But I believe that there is something that can be done to ease the burden on so many. So I look forward very much to hearing the Minister's commitment to doing just that. It's never in doubt, by the way, but I look forward to her confirming that, and not just here in England, but indeed across this great United Kingdom of Great Britain and Northern Ireland altogether. Thank you.
Thank you, Mr. President. It's a pleasure to serve under your chairship. My right honourable friend from Birmingham Northfield, and I'm proud to say that he is truly a friend, has laid out perfectly the historical context in which this scheme was devised and the economic, moral and financial case for change as it fails to meet its objectives today. I rise to speak today as one of the co-sponsors of this debate, both to support this core argument, but also to lay out an aspect of the scheme I think cannot be understood by those for whom it is an abstract point of law or procedure. With a conviction rate of a pathetic 1.5% or so, vanishingly few victims of rape and sexual assault ever get justice through the courts. And of course, we need to use every lever of government to bring down the number of offences and to drive up the number of perpetrators convicted. But to focus entirely on the criminal justice element is to miss the point when it comes to supporting victims. What SEEKR provides as a civil remedy is twofold. First, a level of financial restitution for your experience. But secondly, and most importantly, it is state recognition of your experience as a blameless victim of violent crime. It is that vindication and an important part of the process of closure for people who have been victims of the most hideous crimes, including where a perpetrator has not been apprehended or where a conviction cannot be secured. I spoke to a constituent who was a victim of rape, who told me, quote, "I'll probably never know why the jury decided not to convict in my case. The compensation awarded wouldn't actually cover the cost of a copy of the trial transcript. The process of closure for me began with that letter from SEEKR, that seeking justice hadn't been in vain despite the enormous personal cost. Beyond the nightmares I still have replaying that night, replaying the trial, the courtroom, replaying every indignity meted out upon me over a truly miserable 3-year period, it is there in black and white. On the record, this happened to you. He is a rapist. We believe you." That's what that piece of paper meant to her. Every victim deserves that vindication. Among the largest barriers to that is the time limit. The Victims Commissioner, the indomitable Baroness Newlove, who incidentally is a constituent of mine, recommended to the government that this be amended back in 2019 in her landmark report, Compensation Without Re-Traumatisation, and we are still waiting. This time limit not only pressures victims to choose between pursuing justice in the courts and a civil remedy, lest the defence infer there's a financial motive for coming forward, leaving them with the high statistical likelihood of ending up with neither. But if the expectation is pursuing both at the same time, or even in close succession, it is wildly unrealistic about just how much the criminal justice system re-traumatises a person, putting far too much onus on the victim all at the same time. For the dozens of constituents that I've signposted and supported through this process, that is not a reasonable expectation for us in this place to have of them. It is a huge thing to do, and you can never fully appreciate just how much it grinds you down unless you've been there. The fact that many of those who do apply will be turned away because of arbitrary time limits or are dissuaded from applying for the support they are entitled to at all in the expectation that this will happen leaves them without this ability to get closure. It leaves them frozen. There are 349 victims in Warrington who have had a successful seeker claim in the last 5 years, and from the crime statistics for our area alone, I know that's a massive underclaiming. And then there's all the cases that won't show up in those statistics, including in the family courts. Currently, no agency is responsible under the Victims Code for informing victims about the scheme, and the expectation is that this falls to the police or local support services. I know the Treasury has anxiety about this, but if we get anywhere near our target of halving violence against women and girls, then it will pay for itself. But until such time as we do, victims cannot continue to pay the price in the meantime. While there is not an amount that would ever make being a victim of violent crime worth it, surely the least that victims deserve is the amount that was intended back in 2012, not a fraction of that, as its value is eroded further each year by inflation. For all the things that successive governments have seen fit to spend money on, it breaks my heart that none have thought this scheme worth a consideration. While we work to improve victim support services generally, there will always be a role for seeker in this. Unfortunately, seeker is compensation for state failure. A failure to keep you safe, and too often, a failure to deliver justice. This should be significantly uplifted at the Comprehensive Spending Review in order to ensure that the value is a much more fair reflection of the debt that society owes those victims that it has let down. And those awards must be index-linked to inflation so we don't end up having the same debate in 15 years' time. The time limit should be amended in line with the recommendations of the Victims Commissioner, and we should ensure that the framework aligns with the rest of our system, including with our increased understanding of the harms of non-contact sexual offences. I hope all honourable members will support my honourable friend's 10-minute rule bill next week so we can support this vital piece of reform, and I look forward to the Minister's response today.
Catherine Atkinson.
Dr Murison, it's a pleasure to serve under your chairship. I congratulate my honourable friend for Birmingham Northfield in securing this debate, but also for his powerful and personal speech. And it is an honour to follow the speech from my honourable friend for Warrington North, who was eloquent and forceful. The Criminal Injuries Compensation Scheme is an important fund of last resort to many victims of crime who can't seek compensation through litigation. And in the 17 years I was a barrister before I was elected last year, I represented many victims of crime at its tribunal. I saw the difference that it could make, but I also saw its limitations and the restrictions that were imposed on the scheme in 2012, which seemed more about saving money than ensuring that victims got compensation for the harm they suffered. But I rise to raise a specific concern in relation to a feature of the scheme that I think is indefensible, and one the courts have sought to temper, but where ultimately the scheme itself should be changed to ensure that it has a legally sound and consistent basis. Should be changed so it makes sense. Because it may come as a surprise to many listening that the Criminal Injuries Compensation Scheme applies a different legal test to that applied in our criminal courts when it comes to consent. Unlike our criminal law, the Criminal Injuries Compensation Scheme does not recognise that some people cannot legally consent. And according to Annex B, paragraph 2D, only those who do not, in fact, consent can receive compensation. Now that means that if a victim says yes to sexual activity, even when they were under the age of 16, they are taken to have consented. A child abused or exploited over many years who knows no better than to agree when an abuser proposes sexual contact will not be taken to be a victim of crime of violence because they consented. If the House wants to be horrified by a legal principle that is still good law, it should read the decision of the Court of Appeal in a case called August from 2000. In that case, a 13-year-old boy, described by the then Lord Chief Justice in the criminal proceedings as already corrupt, was paid for sex by a 53-year-old man, but was held not to have been a victim of a crime of violence because he had allegedly consented. Now, it is true that in the years since the case of August, the courts and tribunals have sought to narrow the principle a bit. A few years after the case of August, the Court of Appeal found, some may consider unsurprisingly, that submission was not real consent. And in another case, directed a focus on the applicant's relative vulnerability, subservience, and lesser responsibility as relevant factors. Though many may be surprised that any responsibility in those circumstances was found. And far more recently, the court ruled in the case of RN that sexual abuse causing non-physical injury is included within the scheme. But the very fact that these sorts of workarounds have had to be introduced shows the indefensibility of the underlying principle. We cannot and should not have to rely on tribunals to apply legal rules creatively to seek to achieve just outcomes. I understand that the Conservative government left us with public finances in tatters and public services on its knees, and I understand the concern about expanding the number of victims that might be eligible to compensation. But I hope that the government will consider this clearly inconsistent approach between our criminal law and the law when it comes to compensating victims and fix it.
Thank you, Dr. Morrison. It's a pleasure to serve under your chairship, and I would like to thank and congratulate my honourable friend, the member for Birmingham Northfield, for securing this important debate and for his very moving and eloquent speech. The fact that he only received £1,000 compensation for the very significant injuries he had sustained is an indicator of the inadequacy that we currently have with the scheme. Throughout my career as a personal injury solicitor before I became an MP, and now as an MP, I have tried to be a steadfast advocate for access to justice, and so that victims of injury, including victims of crimes of violence, can receive suitable redress. Compensation for injury represents not just a recognition of the harm inflicted upon victims, but it also provides support and financial redress necessary so that victims of injury can start to rebuild their lives. I'd like to follow from what the member for Birmingham Northfield has said about the criminal injuries compensation scheme. It is a national asset. It's there to compensate people who have been physically or mentally injured due to a violent crime, and to compensate those whose loved ones have died as a result of a crime of violence. But the scheme clearly needs reform. Too often, the system is falling short, leaving victims unsupported and failed. Too many are being blocked from access to justice by an arbitrary time cap, and many are left behind by the long and confusing claims process. The tariff system for assessing compensation means that victims are simply not properly compensated, and the compensation they receive is inadequate in comparison with the actual injuries that they have suffered. And they then have the problem of lodging an appeal, which is again very time-consuming and difficult, and yet another barrier to justice. Yes, of course.
Thank him for giving way, and he's making a very informed speech, as the previous speakers have. does he agree that every year that passes without the tariffs being re-examined, that gap between the award that someone may be able to secure should a perpetrator be identified and they're able to bring a civil case, and the compensation that they may receive through the scheme will grow, and that will add to the sense of frustration and injustice that many victims feel?
My honourable friend makes a very valid point. I do remember the time when I was dealing with criminal injuries compensation claims, where the claims were actually assessed in the same way as a personal injury claim would be. And it was very apparent to us when the tariff system was introduced that it was simply inadequate. The government should therefore commit itself to a review of the current 2-year time limit for the reasons that I have mentioned. I understand that often police will recommend that victims wait to apply for compensation until the criminal proceedings have been concluded so that the trial outcomes are not prejudiced. What that effectively means is that by the time the criminal proceedings have been concluded, the victim has no time to make a claim for compensation because they're out of time. The other problem that I would hope that the Minister would look at is that victims who have suffered traumatic injuries or who have suffered abuse, such as childhood sexual abuse, do not come forward with their experiences until many years later, and that also means that they are automatically excluded from the scheme. There's another point that I would like to bring up, which I understand hasn't been brought up so far, and that is the requirement for the incident, the crime of violence, to have been reported to the police as soon as possible. In my experience, I have found that workers such as those working in hospitals, in schools, often report the violent incident to their line manager, and they believe that that is adequate for the matter to be reported. I totally understand the purpose of the scheme where the victim must cooperate with the police to secure a prosecution, but that the requirement for the matter to be reported to the police by the victim when the matter has been reported elsewhere is again a barrier. And when I have dealt with these claims, I have found that very often the claim has been turned down because somebody working in a hospital, in a school, has reported the matter to their line manager but not reported to the police as soon as possible, and the claim has been turned down for that reason. The system, although the ethos, the purpose of the system is a very honourable one, is not doing what it is meant to do, because people are missing out on their chance to secure justice and to have redress for their injuries. In 2023-2024, only 8% of injured victims of violent crime in the UK applied for compensation. Compensation for criminal injuries must remain an essential part of our justice system, but the current system is inadequate, slow, and inaccessible for too many victims. It is clear that we need reform to ensure that those who suffer from violent crime are given the support and financial redress they deserve so that they can move on and rebuild their lives.
Yeah. Thank you, and it's a pleasure to speak under your chairmanship, and thank you ever so much to my friend for bringing this debate, my honourable friend. I think there's an interesting paradox at the heart of this scheme. The fundamental eligibility requirements are that you must apply as soon as is reasonably practicable and this should normally not be later than 2 years after the incident occurred. The time limit for adults. The time limit can be extended due to exceptional circumstances, and if the person was under 18 at the time of the incident, an application must be received by their 20th birthday if the incident was reported to the police before their 18th birthday, or within 2 years of the first report to the police if the incident was reported to the police on or after their 18th birthday. I mean, I was sexually harassed as a teenager, nothing that would have met a criminal standard, and it never occurred to me to go and do these sorts of things. It is not something that enters the head of 18 or 19 or 20-year-olds, let alone the victims of child rape and sexual abuse. We should be absolutely accepting and implementing the recommendations of ICSA. It is a basic moral requirement. But secondly, when we look at those exceptional circumstances, if you haven't managed to apply as soon as reasonably practicable or within the 2 years,
Due to exceptional circumstances, the application could not have been made earlier, and the evidence provided in support of the application means that it can be determined without further extensive inquiries by a claims officer. That is a much tighter exceptional circumstances exception than most legal exceptional circumstances exception rules. It basically requires that there's no work to do on the part of the agency who would be required to do the investigations. I don't understand why whether or not people get compensation is determined by what is required in terms of inquiries by a claims officer. I don't think that represents justice. And when we look at the number of claims that have been refused, there are significant numbers of claims being refused, nearly 2,000 a year because they're not submitted within the time limit, and another 765 because of failure to report as soon as reasonably practicable in 2023 to 24. What we don't have statistics for that I'm aware of is the number of people who didn't apply in the first place because they knew that they wouldn't meet those eligibility criteria, but I suspect it's substantial. And it seems to me that it is very much an accident of your life chances and various other instances around you, whether or not you hear about this scheme in the first place and whether or not you can meet those requirements. And then that's no way to determine whether or not people should receive compensation. At the moment, we are listing Crown Court cases for more than 2 years hence. The police can take more than 2 years to investigate a crime. It looks to me like about 21% of claims against the criminal injuries compensation scheme take more than 2 years to conclude. In fact, 2.8% of them take over 5 years to conclude. So where the state engages with any of these processes whatsoever, we habitually accept, although we may not like it, but we do fundamentally accept and have done for some time, that it can take the state more than 2 years to deal with a crime. But we do not accept that it can take more than 2 years for a victim to deal with a crime. That seems to me to be a fundamentally irrational and indefensible position. I would also add on this point that we will let you have a claim for breach of contract in this country 6 years after that breach of contract occurred, but we won't let you take more than 2 years to process your trauma. That is not, in my opinion, the right position for the state to take.
Josh Babberin for the Liberal Democrats.
Thank you, Dr Morrison, and I congratulate the Honourable Member for Birmingham Northfield for securing this debate, and I commend him on behalf of my party, and I'm sure everybody in this room, for the bravery that he exhibited in sharing his own story of victimhood and engagement with the Criminal Injuries Compensation Scheme. Victims and survivors in Eastbourne and beyond deserve dignity, respect, and meaningful support when someone has violated their safety, their rights, their property, and violated the law that is there to protect those very victims and survivors. And while no amount of compensation can take away the damage that such acts cause to those victims and survivors, as has been described already, compensation can represent a powerful acknowledgement from the state about what has happened to an individual as a survivor, and can award them with a sum that can contribute towards their healing, spent on whatever it might be, but often spent on trying to access court transcripts, even though they're extremely expensive, or indeed paying for therapy to help overcome some of the mental impacts of crime. But for too long, victims and survivors of crime have been trapped not only by the trauma of their experiences, but by criminal injuries and a compensation system that fails to recognise their suffering in a fair and humane way, often re-traumatising them. And the Criminal Injuries Compensation Scheme has become a maze of bureaucracy and unknown to swathes of victims and those who support victims. And so I think we can all agree that it is in urgent need of reform. Firstly, the scheme must be simplified in order to make sure it's as accessible as possible to victims and survivors, and so that when we, and particularly members like the Honourable Member for Strangford, encourage people to apply if they feel entitled, we should make sure that those barriers are there in minimal form. And submitting a claim is a lot of paperwork, and according to the Victims Commissioner, 40% of victims feel as though they have to secure legal advice to apply for this compensation, which often means giving a share of their relatively small amount of compensation that has not been uprated in line with inflation away. I would argue that in cases where there have already been criminal court proceedings, that even one additional piece of paper to fill in is too much. Indeed, as a survivor of abuse myself that I've spoken about in this chamber, in the Commons chamber and elsewhere, I personally found the prospect of the criminal injuries compensation scheme process too much to engage with. And having spent... Of course I will.
Thank him for giving way, and he's making a very informed speech. On the point around the complexity of the application, and I had cause to see recently the application form for the pre-statutory scheme, and it was simpler than the form which victims have to fill out today. Does he agree that down the years something has gone quite wrong here, and we should be looking to make that process as brief as possible and leave those very detailed checks to those government agencies that have already dealt with the victim of crime?
I thank the Honourable Member for his intervention, and I couldn't agree more that the burden of bureaucracy should not be on the victim. And having spent almost 2 years going through a police process as a victim and then a very traumatising Crown Court trial, the last thing that I wanted to do was rush to fill in forms to apply for compensation before the imminent 2-year from reporting to the police deadline was about to be hit, as the Honourable Member for Wolverhampton West described. And so I did not apply. And for exactly the reasons that the member for Congleton described, it takes more than 2 years to process a crime. In my case, it took many decades, and I still process those crimes today. And the system is not conducive to that healing process. And so a question I asked essentially was, is this system for real? That after dragging me through what is a shocking and adversarial and dehumanising criminal process, you're going to ask me to jump through more hoops just to prove that what has happened to me has happened to me. You can go and take your paperwork and stick it where the sun don't shine. The sun shines in Eastbourne a lot, as many folks in this room know, so I didn't have to go far. But in cases where a court case has happened and where the evidence has already been presented once, it must be possible for the criminal injuries compensation scheme in such a scenario to access that evidence with the consent of the victim and make some kind of compensation assessment without dragging the system through another legal ordeal from square one. I'd be interested to understand what exploration the government has done in this area. Inefficiency costs time, and to the point that was made in intervention by the Conservative member who's no longer in her place, no victim should have to wait years and years for their claim to be assessed, as is too often the case today. And Alexis Jay, in her ICSA report, also suggested that there could be merit in empowering a judge in cases where proceedings have already gone to court to make orders for the payment of criminal compensation from offender to victim. I'd be interested to know what assessment the government has made about the merit of that suggestion too. Now, secondly, the scheme must be more visible. So many victims are unaware of it. Fewer than 4 in 10 victims recall being told by the police about the scheme, according to the Victims Commissioner. And significant numbers of victims and survivors are therefore missing out on the compensation that they need to rebuild their lives. I was not told about the scheme by the police. In fact, I was first told about it by an incredible child abuse solicitor, Dino Nocciavelli, who I was connected with through a friend of a friend. And as has been described already, awareness should not rely on who you know. The system is failing victims and survivors by leaving them in the dark. Thirdly, victims and survivors must receive the support they need to navigate the system. I've touched on some of the complexities, as have other honourable members. And in my case, although I did not end up applying, I discussed the scheme with my ISVA, my Independent Sexual Violence Advisor from Survivors UK. Alan Robertson's his name. I'd love to pay tribute to him. And ISVAs play a critical role in giving survivors the practical guidance and confidence to navigate our justice system, of which the Criminal Injuries Compensation Scheme is a part. But a key concern I have, and one that I've expressed several times before, is that the capacity of charities to provide this support, they report, is being diminished by the NIC's hike and the PCC core funding cut, which I know is a debate that the MOJ will need to have had with the Treasury. And some charities that provide such guidance to victims, like Victim Support, have told me and said publicly that these measures are tantamount to a 7% real terms funding cut. Of course.
I thank the Honourable Member for his speech, and particularly the reference that he's made to ISVAs and victim support. For victims who have been under the age of 18 in the Warrington area, there is actually no support that's available either through the NHS or through third sector organisations for people who've been young victims of violence. And in that context, I think that's why the Seeker scheme is so important, because it gives victims the ability to get specialist therapy outside of the NHS and the charitable sector. Does he agree with me that the ISVA services need to be far better funded so that they can offer much more bespoke support to victims throughout the UK, including child victims?
Yeah, I couldn't agree more with the Honourable Member. As someone who's used ISVA services myself, and I'm not sure I would have been able to go through the process myself without it, I think that the value of those services cannot be underestimated. It is of great sadness to me that across our country there are what I would describe as ISVA deserts, where it is very, very difficult to access those services, and it shouldn't come down to a postcode lottery. People shouldn't be victims of these terrible crimes in the first instance, but where they are, wherever you are in the country, someone should be able to access those critical services and support to help them navigate their trauma, their survival and their recovery beyond it. So I welcome that the government has taken steps to protect funding for organisations tackling violence against women and girls, but we know that there are victims and survivors beyond this cohort who will be left with less support at a time when they need more. Mr. Chairman, the test of a civilised society is how it treats its most vulnerable members. Right now, we are failing that test. Victims and survivors of crime deserve more than our sympathy. They deserve action. They deserve more than a criminal injuries compensation scheme that re-traumatises those it is meant to help. They deserve a scheme that is fair, fast and fighting for them. Liberal Democrats stand ready to work with the government as it prepares its update to the Victims Code and forthcoming legislation with a view to helping to achieve just that.
Shadow Minister Kieran Mullen.
Thank you. It's a pleasure to serve under your chairmanship, Dr. Morrison, and can I congratulate the member for Birmingham Northfield for securing this debate and thank him for being willing to share his own personal experiences. They've been incredibly valuable, and similarly the Lib Dem opposition spokesperson. The criminal injuries compensation scheme is one of the most important parts of our justice system that doesn't simply punish wrongdoing. Crucially, it offers some measure of direct justice, some attempt to right a wrong for those whose lives have been changed by violence and abuse, as incomplete as that attempt may often be. In 2020, the previous Conservative government published the findings of a comprehensive review of the scheme that was committed to as part of a wider review of a first ever cross-government victims strategy. It found at the time that overall the scheme was operating well. The Criminal Injuries Compensation Authority was dealing with over 30,000 applications a year and had a high satisfaction rating of 95% from applicants who've been in contact in the preceding period, and those levels of satisfaction have been broadly maintained. What today's debate has already done is to highlight within broad levels of satisfaction that can often be very serious and consistent failings of individuals that it's important that we don't take for granted. But it also recognised there were some changes, improvements that could be made, and so launched a consultation on a number of areas seeking to make the scheme simpler, more transparent and easier to understand and engage with for victims. For example, the approach to classifying and compensating for disabling mental injuries, overhauling how brain injury was represented and reforming the groupings of other injury types. It also proposed changes to bereavement awards. Members may well be aware that there was a further need to launch a targeted consultation on the unspent convictions rule to ensure it was fully and comprehensively reviewed for possible reform. Under this rule, an applicant's compensation award could be reduced or withheld depending on the sentence imposed for an unspent offence they had committed. The Supreme Court has previously found that this unspent convictions rule was lawful and that rationale underlying it was legally sound. The judgment also rejected the notion that vulnerability which leads to later offending should require any kind of special exemption from the rule on the basis that the criminal justice system already should include measures to allow any vulnerability of victims to be taken into account at the time of their prosecution and sentencing. Following this, there was further impetus to consider change as the government sought, quite rightly, to respond to the final publication of the independent inquiry into child sexual abuse, which made further recommendations regarding the scheme, as a number of members have touched on. The 2023 consultation was focused on time limits and the scope of the scheme. It considered the inclusion of online abuse within the definition of a crime of violence. It looked at whether children who suffered abuse should have longer to apply for compensation, and it raised the question of whether non-contact offences should be brought within the eligibility criteria. I think the variety of consultations and additional areas for reform reflect what's been a rapidly evolving area of political and public concern that has created a greater and greater focus on groups of victims as our understanding of the nature and impact of sexual abuse, particularly historical, domestic abuse and online harms, has broadened. Across the consultations, hundreds of responses were received and difficult questions were explored in detail. But before a final response was published, the 2024 general election was called. The government last month has sought to move forward and resolve these pieces of work and progress from this extensive background, but it's taken a decision not to make any changes to the scheme's scope, time limits or the unspent convictions rule at this time. I think it's important for the Minister today to clearly explain why. I recognise the concerns around singling out particular categories of offending and the unintended consequences of these sorts of changes, but I think the concerns arise when the guidelines that attempt to allow for exceptionality that do exist aren't operating as well as they should be. And so in the instance where the government chooses not to make formal changes to the rules, there's an even greater emphasis, as the member for Birmingham Northfield described, on ensuring that the guidelines that operationalise the exceptionality clauses that do exist are functioning as they should. On unspent convictions, the government has laid out reasons for not changing this at all on the grounds, again, of creating unintended consequences for victims. But of course there was a proposal for reform put forward that would have allowed you to maintain, the government to maintain a overall barring of people seeking compensation despite the nature of their offending, through considering whether lower level offences, community offences for example, could be removed from the disbarring applications, or whether there could be a significant gap between the injury suffered and the nature of the indexed offence that would be universal, not seeking to single out particular types of offending. And I would be interested why the government didn't take forward that possible suggestion. I'd also like to ask the Minister to explain further their failure to provide a comprehensive response to the 2020 consultation with all those very many suggested reforms. They've said, and I quote directly from the Minister's forward, that I've decided not to publish a substantive response to the 2020 consultation as the victim support landscape has changed substantially since 2020. I'm concluding that consultation by writing to the Justice Select Committee notifying it of my decision. I will.
Does the honourable gentleman see that there is some degree of irony here in him asking why our current minister hasn't responded to a 2020 consultation when his government, which was then in power for another 4 years, didn't do so?
I think I quite clearly laid out the timetable and the sequence of events, particularly in terms of the courts requiring a further consultation and then a sensible decision to further respond to the inquiry consultation. I'm more interested in actually getting a response. I appreciate that the member seek to make a party political point, but that's fine. On the face of it, I have to say it's slightly disappointing not to see that comprehensive response, notwithstanding the concerns of the member opposite, as I think that 2020 consultation and the very many proposals within it, some of which were implemented on an interim basis, were important. Doesn't mean the government has now entirely rejected some of those other changes that I've outlined, or will the letter set out in more detail which changes will or won't be taken forward, and the reasons why I think it's important for the government to do that. And whilst the scheme may be working well overall, we should continue to consider where challenges remain operational, as I've said. We also know the experience of applicants varies regionally. In Birmingham, for example, which includes the constituency of the member who secured the debate, the average time for compensation decision was over 490 days in 2022. And whilst there has been some improvement, wait times are far too long for some individuals, even if the majority receive their compensation in a timely manner. As I've said, we've heard from a number of members today about individual cases and their personal experiences, and it's important that we hold the government to account for ensuring that as many people as possible, and as great a ratio as possible of people who apply to the scheme are receiving an adequate service. Chair, the true measure of our commitment to victims is not the volume of our pronouncements, but the effectiveness of the systems we create to maintain it. I want to finish by saying this. The Criminal Injuries Compensation Scheme has always been about more than money. It's about recognising harm and restoring dignity. The Conservative government took that responsibility seriously. We listened, we consulted, and we left a clear foundation for action. Now it's for the government to build on that foundation, and we'll hold them to account simply because victims deserve nothing less.
Thank you, Dr Morrison. It is a pleasure to serve under your chairship today. And can I thank my honourable friend, the member for Birmingham Northfield, for securing this very important debate on an important topic. And can I thank all honourable members who have taken part. I think the strength of feeling here is palpable today, and I have heard you all. I have also been deeply moved to hear the honourable members' personal stories about being victims of crime and its impact that it had on them. I thank them all for their courage in speaking out about this experience so eloquently. Doing so is powerful and illustrates their views both on the Criminal Injuries Compensation Scheme and the experience of applying for compensation, and I commend their desire to see improvements to the scheme and how it operates. Can I also echo my honourable friend's thanks to the brilliant staff who work to operate the scheme so tirelessly and the work that they do every single day to support victims of crime. I have a long-standing commitment to supporting victims of crime. Since I took on responsibility for the scheme, I have been struck by the bravery of victims of crime who speak out about what they have been through and how it has affected them. Sometimes I am contacted directly by victims and sometimes by members of this House. Other times, I listen to and learn from high-profile figures, including the Victims Commissioner for England and Wales, and from the organisations that work so tirelessly to support victims. Whatever the medium for conveying individual stories, I am constantly reminded of the importance and responsibility of my role as Minister for Victims and Violence Against Women and Girls. This debate today has added to my awareness and sense of purpose to do what I can and all I can to support victims. The Criminal Injuries Compensation Scheme has a long history, with the first non-statutory scheme launching in 1964. It has changed over time, including when it became a statutory scheme in 1996. However, its purpose has remained constant: to recognise the harm experienced by victims injured as a result of violent crime. The scheme is a last resort for compensation where someone cannot obtain it from the perpetrator directly or via a civil claim. Through the scheme, we meet domestic and international obligations. The scheme for Great Britain remains one of the most generous in Europe and the world. It pays compensation for physical, sexual and mental injuries, and also for things associated with those injuries like loss of earnings and special expenses. It also provides compensation to families bereaved by violent crime to acknowledge their loss and provide support to dependents. As my honourable friend said, the previous government announced a review of the scheme in 2018. It then held its first consultation in 2020. This was wide-ranging, looking at various aspects across the whole scheme. There was a second consultation in 2022 on the scheme's unspent convictions eligibility rule. The third and final consultation was in 2023 and considered the scope and time limits of the scheme. The second and third consultations, of course, included consideration of the recommendations of the Independent Inquiry into Child Sexual Abuse, often referred to as ICSA. The last government did not respond to any of the three consultations before the election was announced last year. One of my key priorities when I became Minister was to consider how to conclude the previous government's review. I saw how many individuals and organisations had taken the time and in many cases expended a great deal of emotional energy to respond thoughtfully to the issues considered in the consultations. They deserved to know the outcome of following their contributions. At the forefront of my mind, as I considered how to respond to the consultations, were the ICSA findings and recommendations. There is no doubt that the sexual abuse and exploitation of children are of the most heinous crimes. It takes a great deal of strength for victims to come forward and seek justice by reporting the crime to the police and to access support and compensation to aid their recovery. Earlier this month, I published my response to the 2022 and 2023 consultations, which concerned the ICSA recommendations. As has already been mentioned, I also wrote to the Justice Select Committee about the 2020 consultation, concluding that consultation and informing them of my decision not to publish a substantive response in relation to it. My conclusion was not to amend the scheme at the present time. I have made no secret of the fact that this was a difficult decision for me to reach. In the same way that I have listened to and learned from you today, I have learned from the respondents to the consultations. I understand and I hear your calls for change, and I am considering how we can best support victims with whatever they might need with an improved and effective service. Although my decision was a difficult one, it is the right one. It is the right one for the scheme and for all of the victims of violent crime that it supports. Regarding ICSA, I fully appreciate the basis for the recommendations that the scheme be amended and expanded for victims of child sexual abuse and exploitation. I also acknowledge that many of the consultation respondents call for change in the way that ICSA recommended. However, it is my belief that all victims can feel a need for their suffering to be recognised, no matter the nature of the violent crime that harmed them. This belief aligns with the core principle of the scheme, that it is universal. This ensures that all victims can equally access the scheme. We cannot have one rule for certain victims and one for another who have experienced other, often deeply damaging crimes. Payments are based on injury or bereavement arising from violent crimes, regardless of the nature of that crime. And this is why I decided not to amend the scheme as ICSA recommended. Importantly, the scheme continues to be subject to scrutiny. The Victims Commissioner for England and Wales recently proposed reform on the scheme's time limits in her report on court backlogs. I responded to this report on the 25th of April, and I am considering another report of the Women and Equality Select Committee, which has recommended that the scheme be expanded to enable victims of non-consensual intimate image abuse to access compensation. This leads me to explain a little bit more about why I decided not to respond substantively to the 2020 consultation, which covered all aspects of the scheme as a whole. Now, I appreciate that my decision means that the many people who responded to that consultation will not see change as a result of their contributions, nor will the concerns they expressed be answered. The key reason for my decision is that the landscape in which the scheme sits has changed significantly, Dr Morrison, since 2020. The questions that were asked in a context which is now totally different. Government provision and support for victims has developed, but at the same time, demand for that support in all of its forms has grown substantively. To put simply, the context has moved on. My honourable friend and other MPs spoke eloquently about their experience several years ago. I am hopeful now that some of those challenges would not arise today. The Criminal Injuries Compensation Authority, or CICA, which administers the scheme, has worked hard since 2020 to improve its service. For instance, all applications can now be online, discarding the need for that onerous amount of paperwork as described by honourable members. All the staff have undertaken trauma-informed training, and CICA now has dedicated caseworkers for the most complex of cases. CICA also runs awareness training sessions for stakeholders who support victims like the police and ISVAs and IDVAs. All of these measures help to improve victims' experience when applying for compensation. There are, of course, other challenges, as we've heard today, and I want to reassure honourable members that we are not resting on our laurels. We are committed to continuously reviewing and responding to feedback from stakeholders, and CICA undertakes user research, cross-agency working and outreach activity. This facilitates sharing experiences, learning and collaboration to improve its service, and I always welcome feedback from honourable members, from their constituents and from victims directly about the service. We are also working hard for victims more generally. The Victims and Prisoners Act was passed in 2024. It aims to improve victims' experience of the criminal justice system. It makes it clear that victims require services under the Victims Code, and it strengthens agencies' accountability for its delivery. My friend, the Honourable Member for Congleton, and other Honourable Members mentioned how do we raise awareness and how do people know about the right to access compensation. Well, the Victims Code includes the right to be told about compensation. We are now implementing reforms in the Act, and we aim to consult on a revised Victims Code in due course. And, of course, we await the reports of Sir Brian Levison's independent review of the criminal courts, where we should be making it easier for victims to seek civil remedies from the perpetrators directly themselves. I will happily give way.
In the event that we are creating a right to be made aware of the things, if a claimant can demonstrate that they weren't made aware, could we amend the exceptional cases review so that that falls automatically within that exception?
I welcome my honourable friend for her contribution. It is, of course, something we can consider and look at. We are currently going out to be revising on a new Victims Code in due course. The Victims Commissioner meets with me regularly to talk about compliance of the Victims Code and how we hold agencies accountable for their failure to uphold the Victims Code. So this can, of course, be considered. But as well as compensation, the Ministry of Justice provides funding for vital victim and witness support services. This includes community-based services, in addition to the funding that we give police and crime commissioners to allocate based on their assessment of local need. Across government, the financial situation is difficult, and the outcome of the spending review is awaited. Going forward, this government will be considering how it can best provide the support that victims of crime need and deserved. And, as a proud Welsh MP, I can reassure the Honourable Member for Strangford that I am due to meet with my counterparts in the devolved nations very soon to discuss how best we can support victims of crime wherever they reside in these isles. So, I want to reassure Honourable Members that you have all been heard today, in the same way that I have heard the respondents to the consultations. Your message to me is that we need change, less consultation, less talk. We need action. Listening to your experiences and your views and suggestions today will help me consider how we can best improve the system, make it effective, make it workable, and to provide victims with the justice that they so longingly deserve. I am very, very grateful to my honourable friend for his contribution to this important debate today and to all of his work in supporting victims of crime. Thank you, Chair.
Lawrence Taylor to wind up.
Thank you, Dr. Mearison. I will not detain members long, but I do wish to thank everyone who has spoken in this debate for their informed contributions and the tone of this debate. Of course, it is right, and it is a critical part of our function that we scrutinise and criticise records of past governments and the present one. But I think all our honourable members in this debate have approached this subject with the seriousness and the sensitivity that it deserves, and we all share the common aim of wanting a scheme that delivers more for the victims of crime. From the backbenches, we heard contributions from the Honourable Member for Strangford, and although he described some of the differences in Northern Ireland, I was struck by the similarities with some of the frustrations that victims experience in England, Wales and in Scotland. My honourable friend, the member for Warrington North, made a speech that combined powerful empathy with acute reading of some of the technical challenges that still exist within the scheme. I'd also like to thank my honourable friends, members for Derby North, for Wolverhampton West and for Congleton, who brought their professional experience and expertise to this debate, and this debate was enriched by their contributions. I was struck in particular by the issue that my honourable friend, member for Derby North, drew attention to. I think she highlighted an extremely important issue, and it should be a matter of concern for all of us that apparent dead letters in the law can be reanimated with sometimes a surprising lack of scrutiny. I think she highlighted a very important matter that does need remedy. From the front benches, we heard contributions from the honourable member for Eastbourne, who spoke for his party, but he spoke for himself as well. He has described his own experiences before in this place, and I know that he has used that experience to try and bring forward his own legislation on related matters, and I thank him for his contribution today. We heard an account from the Honourable Member for Bexhill and Battle, and it is very important that we hear that account arising from the opposition party in this debate. He highlighted one issue which I think perhaps does need further scrutiny, which is the satisfaction rate which was claimed. I have to say, from my own experience of the scheme, I do not recall ever being asked to give a satisfaction rating. I do wonder whether there are issues relating to how people asked, what are the response rates to that question. I must say that 95% figure is quoting is surprising to me. And from the Victims Minister, the Honourable Member, my friend for Pontypridd, she set out a overview of all the contributions that have been made in this debate. I was particularly struck by her comments that changes will not be made to the scheme at this present time. And I do think it is important that if changes are made to this scheme, that they should not be driven by a short-term desire for cost savings. They must be motivated by the improvement of that service for victims. I do think, on balance, it is right. Is it in order to give way? In that case, I'd be delighted to give way.
I thank my honourable friend for his summing up, and just wanted to pick up on that point, because certainly when the white paper came out in 1993 about two governments back and the changes that they wanted to make to the scheme, they said that it was driven by, quote, providing a better service to claimants, but then admitted that its main aim was to cut the cost of the scheme. And I think it's clear from the debate that we've had today that it's really important that cost-saving measures are not what's driving the changes. It's making sure that it is about the better service. And would he agree with me that that needs to be the core focus above any other considerations from the Treasury?
Well, I thank my honourable friend for that contribution. I'm delighted to hear a white paper from 1993 being spoken. I'm a great believer that obscurity is a source of strength, and I think she's provided some evidence for that theory today. I do agree that while, of course, the Treasury takes a legitimate and necessary interest in annually managed expenditure, on the other hand, there is a real risk that changes that could be made at relatively short notice and through curtailed scrutiny time in this place could result in changes that actually deliver a worse service. That must be avoided at all costs, as indeed I think we have seen from some of the negative experiences of changes to the scheme in the past. So, building on the Minister's, I think, welcome commitment to continue to work with members of this House and victims across the course of this Parliament, I do hope that we can secure some of those positive changes that I know she wants to achieve. I'd like to thank all the members who supported the application for this debate, including some who unavoidably could not be here today, including members for Worsley and Eccles and South West Devon, who've given notice. Unfortunately, they're detained by other matters. This is the first debate on the important matter of criminal injuries in this Parliament, but I am sure that it will not be the last, and I thank everyone for their contributions and your chairship, Dr. Murison, today.
Thank you. Contributions are always more powerful when they're rooted in personal experience, as we've heard today. The question is that this House has considered compensation for criminal injuries. As many as are of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. Order, order. Hello.